the specific policies in the country. So this morning, we will begin with Hlengiwe Dube, who is from the Center for Human Rights and was the lead consultant in the processes to develop the toolkit, which we will be launching at the beginning of next year within the first quarter. After that, we will have 3 speakers who will give us lightning talks. There will be Chennai Chair, who's a Mozilla Fellow looking specifically at artificial intelligence, gender, and the right to privacy. Will then be followed by Dumisani Nkala, who is the Business Development Director at an internet access provider in Zimbabwe. And she will look at what the data protection concerns for African business are. And I'm also happy to note that Dumisani has also been interacting quite a lot in terms of just, the regional business communities, internet governance processes. And then lastly, we'll have Advocate Phansi Tlakula, who's not new to many of us from the digital rights community, who now is currently the chairperson of the South African Information Regulator. And she will be giving us, the real lowdown on the experiences of, data protection regulation on the continent. So now I'll begin by handing over to you, Hlengiwe, to give us the presentation on the Advocacy Toolkit. Thank you so much.
Thank you so much, Kwaliwe, for the introduction. Yes, my presentation is going to be on the toolkit. My name is Hlengiwe. I am based at the University of Pretoria Center for Human Rights. So we've been working together with the AfDec Coalition on developing this data protection advocacy toolkit, which we are expecting that it's going to be a very useful tool on the continent for advocacy purposes. And just to mention that we had an opportunity to showcase and validate this toolkit during our conference that happened in last month, where we were also partnering with AfDec Coalition, and we got very valuable feedback from different stakeholders that were participating in that conference. So this toolkit is, like Kwaliwe had said, a product of the work between the Center for Human Rights and the advocates and the AfDec Coalition. What it does is to provide standards on data protection and privacy on the continent. And we are hoping that after we have finalized it, it's going to be a very useful resource for anyone who desires to work on issues around data protection and privacy, and also just to understand the human rights-based approach on specifically looking at privacy and data protection. It's a useful tool for engagement. It's a useful tool for informing policymakers, for engaging policymakers, for general awareness, education, for human rights practitioners, for our national human rights institutions, for the data protection authorities, and everyone generally, because privacy and data protection are universal. They affect everyone, so they are relevant to everyone. So basically, the toolkit is divided into 3 parts. The first part is the introduction with key issues on the international and regional framework. And then the second part looks at the content of privacy and data protection. And then part 3 looks at duty bearers, rights holders, and then also under part 3, there is a very detailed toolkit, and there are also recommendations for role players that we identified, which of course is not an exhaustive list, but just indicative of some of the role players that are important or significant in the area of privacy and data protection. So, Kweliwe, how many minutes do I have?
12.
Okay. So the toolkit, I'm just going through just what the toolkit entails. The toolkit looks at, you know, the human rights-based approach itself. There's a breakdown, an elaborate breakdown of what entails a human rights-based approach, and then also then it delves into the African context and looks at privacy in the context of our African constitutions, and also specifically looks at communication issues in such provisions in the constitutions. And then the frameworks on privacy and data protection, looking at other regions as well. So there's a bit of insight of, you know, the European framework, and also coming to the African, you know, framework, looking at our Malabo Convention, the sub-regional frameworks, and cascading down to national level, and looking at different data protection legislations on the continent. And then also important is what is in the toolkit is also an outline of the principles of data protection, such as accuracy, you know, data minimization, transparency, and all that. And then all this, we look at all these elements, also trying to locate some of these principles in the data protection laws on the continent in different countries. So just providing, you know, case studies or on the continent. And then the toolkit looks at, like I've mentioned, the duty bearers and the rights holders. So under rights holders, it gives a rundown of what the, you know, the rights of data subjects are, who are the rights bearers, and what are the obligations of duty bearers, looking at data processors, looking at data controllers, looking at the roles and you know, the duties of the national data protection authorities. I'm sure from this conversation, as Advocate Lakula presents, you'll get an insight of what a national data protection authority does, at least in the context of South Africa. After that, there is a very detailed checklist, I think, which is one of the major elements of the toolkit. There is a checklist which is in the form of questions. And the checklist is you know, a tool for measuring compliance. And it has questions on, you know, the silent issues of data protection and privacy. And these includes, there are questions around, you know, questions around data protection standards. There are questions on data protection authorities. For example, like under the data protection authority, questions would include the fact that is that authority independent? Is that authority well resourced? What is the mode of appointment, you know, for the, you know, data protection authorities? What are the obligations? What powers does it have? And then we look at you know, questions regarding the purpose of data, of processing of personal information, questions regarding data controllers and processors, data retention, the quality of personal data, and issues around consent. You know, it's a very significant element of processing personal information. So there are several questions regarding consent. There are several questions regarding data security, or the notification obligation in you know, in the context of data breaches, data transfers, vulnerable groups as well. We know that, you know, there are certain groups who are more vulnerable than others, and also there is extra safeguards that are needed to, when we're dealing with such groups, and also issues around sensitive information and whether they are available in a certain jurisdiction. Are they available safeguards or extra safeguards for processing of sensitive information? And after the toolkit, after the checklist that I've just spoken about, there is also the section on guidelines for policymakers. So when we were designing this toolkit, we were, you know, the idea was that, it has to speak to policymakers as well. And what are the issues that policymakers have to take into consideration when you're looking at data protection and privacy? And the issues that are identified under the guidelines for policymakers include data protection and privacy as a human rights issue. Hence, we are relying on the human rights-based approach as the conceptual framework in this whole thing. And then also looking at justifiable limitations with the understanding that the right to privacy is not an absolute right, but it can be limited under certain circumstances. And the toolkit also defines some of the circumstances under which the right to privacy can be limited. And then also issues around transparency, participation, empowerment, legality, the accountability, obligation, access to remedies. And we've seen data breaches happening, and there is definitely a need for victims when such victims for accessing effective remedies when such violations take place. So that's one of the important areas that we've included under issues to consider for policymakers, and also the development of an effective framework for privacy and data protection, which in some other countries it exists, in some other countries it doesn't exist. So there is need to look into, what is pertaining in a jurisdiction. Do we have a data protection framework, and how effective is it? And where there is none, what can be done? Such issues, and also issues around strategic litigation is a very important factor to include in this area. And then the last section of the toolkit looks at recommendations for role players. And like I've just mentioned, that privacy and data protection issues affect everyone. There is no one really that can say that they are not affected by, or it doesn't concern them. So, but what we've managed to do is to identify certain role players and tried to come up with certain recommendations for the different role players. So we have role players starting from the African Union Commission and the human rights bodies under the African Union. So we have identified the African Commission on Human and People's Rights, the Committee of Experts on the Rights of the Child, the Pan-African Parliament as well, the African Court, such bodies. And then we try and come up with recommendations for these. And then we from the continental level move down to the sub-regional level, the ECOWAS region, East African region, and also in the SADC region. And then we look at national human rights institutions, like institutions that have been mandated at national level to look at human rights issues in a country. What role could they play in a data protection regime, or in the privacy and data protection regime? Issues around awareness, issues around monitoring and implementation of the right to privacy, liaising with the national data protection authorities. And then also we have this segment, which is the civil society. What is the role of the civil society in data protection and privacy? We're looking at issues around awareness. We're looking at issues around, civil society participating in formulation of data protection frameworks during public consultations. We are also looking at the role of civil society in engaging even at continental level bodies, such as the human rights bodies that I've mentioned. We are also looking at issues, also another role player, the children's rights activists as well, as part of the civil society, but being a specialized group. And privacy and data protection issues affect children differently. So we also have such recommendations pertaining to children advocates, what they can do, and also gender justice advocates as well, because there's this whole gendered dimension when you're looking at privacy and data protection. And then we've got recommendations again for parliamentarians. What could parliamentarians do? Formulating certain laws, whether it's that comprehensive data protection law or their sectoral laws on privacy privacy and data protection, measuring the implementation and all that. And then we have another very important group when we're looking at issues around democracy, and that is the electoral management bodies. And you know that there's processing of personal information during the time of elections, and that has not been adequately looked into in our African context. So we thought that it's very important to include the electoral management bodies and their roles, and how they can also be in liaison with political parties and also in liaison with the data protection authority. And then another role player that we identified is the business community, and I'm glad we have a member from the business community. But we also have our own recommendations that we have formulated around, that role player. And there's a lot of information, our personal information, that is in the hands of the business community or the private sector in general. And we believe that there is a lot that can be done from that area, or from that sector. And then we have the judiciary and law enforcement as well. They also play a very important role. I mentioned before the issue of strategic litigation as well. And so hence we see here the role of the judiciary in some of the recommendations around that group. I think I am done, Koliwe.
Thank you, Hlengiwe. Thank you so much for that. I think one of the things that I should mention also around development of the toolkit is some of the issues that Hlengiwe made reference to, issues specifically relating to the electoral bodies, the gendered dimensions, are issues that came out of a validation process. So what we did after the consultants working on it, which is the Center for Human Rights and Alt Advisory, is that we went back to 5 countries that already do have data protection legislation in place, to get them to convene validation meetings. And this was also done at a broader or wider level at one of the African conferences on data protection that was hosted by the center. So I've just been checking the chat, and I don't seem to see any responses or reactions to any of the issues. My colleague Jenny Montenant is in the meeting as well, and will be assisting with the questions and identification of any hands up, which I don't see. I would say that it would be then safe for us to go to the next speaker. So in this next section, we're going to be looking specifically at thematic issues. And I'm happy that Hlengiwe spoke to the issues of gendered dimensions. Chennai, being a colleague of mine, also has always had complaints around the fact that we always bring in gendered issues right at the end of the session. So she's going to take up the mic next. And Chennai is going to be looking specifically at artificial intelligence, gender, and the right to privacy. The right to privacy in relation to the different varying sexual and gender minority groups. So over to you, Chennai. Thanks.
Thank you so much, Koliwe, and thank you to Hlengiwe for the presentation and setting the scene. I just want to make note that I am very excited to be on what I consider an all-star panel with women, firstly, and also to be in a conversation where we are including gender right at the start, not having a separate gender panel, which often doesn't have everyone in the audience. So I would like to commend you on that just to kick off my session. So in responding to the presentation and the toolkit and being part of the process, I would just want to take one step back. So for me, the starting point in thinking about issues around data in the context of emerging technologies, in this case, what I'm focusing on, artificial intelligence, it's also about locating it in the context. So in our African context, we exist in a space where there are issues of inequality that are experienced at the intersection of your gender, your race, your sexuality, your class, your access to education, and also, basically the structure that we exist in that is often patriarchal, that determines what a person is in comparison to who is considered more important in society. So then with these conversations around data, we begin to exist in datafied societies where at the end of the day, what is driving innovation, what is driving emergent technologies is around data. And oftentimes in the data protection conversation, we focus on the personal data, the personal information, but with these new technologies, artificial intelligence, especially in the way that it is then takes aggregated data sets and is able to then conduct automated decision making, or the algorithms that we often joke around determining what we see on platforms. These, when they're aggregated, can actually have an impact on points of personal information or sensitive categories. So I don't necessarily have to put in to say that I am a woman when I am selecting a platform, but because of my activities that I carry out on different platforms, and when the algorithm is built, it can determine that this person is more of a woman, or this person may be more, maybe part of a sexual minority group. So those are the issues that I wanted to just preface in thinking about artificial intelligence and how it relates to this conversation around data protection. So in that background of the inequality that we exist in, and also the datafied societies, for me, the questions that emerged when I was thinking about data protection is, we can have this necessary legal instrument at an overall African level, but what we need to tackle with is in terms of, are we responding to this idea of this notion of data protection in a vacuum, where we look at data as a currency, as oil, but we're not thinking about it in terms of it's coming from people, that context of community. And then also we think about, are we setting up these laws to ensure that we are compliant at a global level, or are we thinking about them in order to safeguard our communities that we exist in, that we already know in these contexts of digital inequality? And I think what is most important is who benefits. Who is actually directing this conversation of data protection? Who will actually be able to say, we have these rights that Hlengiwe has talked about for the data subjects, which I prefer to call for people. But at the end of the day, is everyone at the same level ever actually able to then, make use of this law, make use of the existing regulations to then say, my privacy has been violated, or a data breach has happened and my bank did not inform me up until 6 months later. Where do I go? What do I do? So I'm very excited that we have these different panelists on the group, and also to have, business sector and the information regulator present, so that these are the questions that we think about, not just the laws themselves, but the context in which we are actually developing them. So my work in terms of understanding artificial intelligence came from, support from Mozilla, which has this new mandate where they're trying to understand the impact of artificial intelligence within the consumer space by developing the notion of trustworthy AI. And often when we think about data protection, my perception is that we have this instrument as a way to ensure trust on the online spaces, trust in engaging with new technologies, because we've seen governments roll out AI-based innovations such as chatbots. We've seen the rollout of AI-based solutions in banking systems in order to determine who has access to finance. So at the end of the day, the idea of trust is important, and when we're thinking about data protection and thinking about data. So I focused more on gender and sexual minorities because the literature that is out there, the research that has been done in thinking about the impact of artificial intelligence has identified that the people who are more likely to actually face harms as a result of these new technologies are people at the intersections of inequality of gender and sexuality. And we know that in our reality, we're currently in the season of 16 days of activism against gender-based violence. I am in South Africa, where gender-based violence is so rife that it was declared a second pandemic. So the question becomes, as these new technologies are taking up all of these data, are they going to then respond to the current context so that we can actually use them, as in the case of an AI chatbot that was developed by Soul City and AI for Good UK, where they support gender-based violence? Or is it going to actually exacerbate social injustices, as in the case of deep fakes now being, like, there was a platform on Instagram where someone could send a picture and then it would be infused into a pornographic state. So deep fakes actually being then used to act on as a form of violence. I'm only using this as an example, but there are several other cases that have been raised in thinking about the impact of gender and privacy and data breaches, such as increased surveillance, not just at a government level, but also at a family level, at like a societal level, and even with private sector, making use of personal data for business purposes, selling it on to third parties. And this was a case that was highlighted by Privacy International in their work on reproductive rights and menstrual apps. So we already have these existent examples, but at a global level. And then we also have cases of facial recognition trying to gender people. And then it doesn't work if someone is in a state of transitioning from men to women, so transgender people. And then that's the question that emerges of how are we actually responding to the realities of these harms as a result of the data that feeds into these systems, and how then they are designed. Are our data protection guidelines sufficient? So then in responding to the toolkit, I just want to specifically focus on some of the findings that emerged, and how I do hope that going forward, as we're thinking about data protection, some of the recommendations that emerged from the study. And just to preface that, it was specifically focused on South Africa, but I do hope that, you know, other people are on the call, or other people in other countries may actually take up this research or conduct more impact assessments of new technologies and actually locate them within the conversation of data protection and privacy. So what we found, what I really did find, was that in South Africa, we have the POPI Act, the Protection of Personal Information Act, that was instituted in 2013, but has now come into full effect. And I think that provides provisions in thinking about like privacy and data protection. Specifically, there is actually a provision for protection against Section 71 on automated decision making. So then that has some layers of provisions for, okay, this is a basis to think about how do we protect data in context of artificial intelligence. To note again, because it's not just about personal data, it's just about the information that comes out and then the impact that it has. So the provisions for data subjects' rights are very important, and I actually do commend that South Africa has had this robust data rights for data subjects put in place. But the key challenge has been in thinking about this, and even for the data, for the toolkit, the language that's used, right? So oftentimes he or she was used in reference in the document, but then this may be exclusionary. So this is people actually accessing the tools that you've set up, but is the language inclusive for everybody who may not identify in that binary? And also thinking about context responsiveness, right? So then to what extent are these current laws responding to the realities of that consent is not always possible in our current existences, where in cases of digital inequality, digital literacy and digital skills, where someone can actually be given a document and they follow through the system of, say, probably tick boxing or accepting, okay, I'm giving up my data, but it's more so because they want to access a service, not necessarily that they do understand what's going on. So those are some of the issues that the research, which will be launched in December, was unpacking in terms of thinking about, can the Protection of Personal Information Act actually provide a basis to build up more on data governance with regards to AI? And in what ways can we build up on it in a way that allows for there to be safeguards for gender and sexual minorities, and at the same time allow for ownership and control of data for these people, for marginalized groups, in a way that addresses community needs? So then, Kholiwe, just to end off in terms of thinking about recommendations around AI and data protection, and also that may be possible to reflect on for the toolkit, a lot of work that needs to be done has to be holistic. And this is why I was excited reading the toolkit, in that it identifies different stakeholders and what can be done. But I think it's also about that contextual aspect of it, of located in context, so that people understand why it's relevant to have a data protection advocacy toolkit. And it's not just for people who are in the digital rights space, it's for everyone who actually interacts with data, so that you actually are able to know your rights and where to go and how to advocate for better treatment of your data, and actually hold companies accountable, hold government accountable for whoever actually makes use of your data. So one of the things that's really important is to always reflect on context. And whilst the toolkit has been designed to be a framework that other people can use, I do hope that that those who do make use of it reflect on it within their particular context of how does it apply in the social, economic, and political context. And to also think about it in terms of capacity building. With artificial intelligence, it is such an evolving field where some people call it the snake oil, where people sell things that are artificial intelligence but are really not. So then we also have to think about it for policymakers and regulators and advocacy groups. The building of capacity to understand the link between these new data-driven technologies and how they impact privacy and data protection, so that everyone has a role to play in terms of capacity building. And then also breaking down silos in governance. The issues that I've raised in terms of gender and sexual minorities would probably fall into a ministry that's concerned with welfare or anti-discrimination, but actually there's a need for collaboration with the different sectors that address these issues, so that what we build up in response to trying to safeguard marginalized groups is not happening in silos, but actually is responsive to realities of other ministries who deal with this on a daily basis, other ministries and other sectors. And then what's important also is to have oversight bodies. So to be able to actually monitor and evaluate the strength of the data protection laws themselves in place, the advocacy toolkit, is it going to be sufficient? Does it actually cater for marginalized groups? And actually working with other entities like I've named before. What I suggest in the South African context is collaboration with the Commission on Gender Equality in South Africa, where when you do engage the Gender Equality Commission, they kind of are like, that is dealt with in the Film and Publication Board when you're specifically looking at, you know, gender-based violence through non-consensual intimate image sharing, which is through the deepfakes. And then also the need for civil society and legal community to work together for purposes of strategic litigation. What is likely to happen is that in this instance, we are now able, we've framed that we've got data protection advocacy toolkit. We've got countries with data protection laws, but now we need to build up the cases of potential harms that may happen, so that we don't have to rely on examples of research that has been done in the global north, where they've documented these cases. But I think what's most important, and this is, perhaps the business sector can also respond to this, but it's very important to resource the Information Regulator's Office. It's very important to resource those who will be working on this data protection advocacy toolkit, because at the end of the day, what we want is to be able to have this toolkit as a living document that can be adjusted and responded to. And that requires resourcing in terms of who is actually able to participate in this process in terms of their time and the commission for that time, but also to think about, does the information regulator in that country have enough support in terms of actually addressing the issues as they emerge? And also, what role does the technical community play in their different sizes? Because I cannot ask a startup to be able to contribute, whereas you've got an organization such as Facebook that may be able to contribute a larger sum. So these are some of the issues that, as I was thinking about the toolkit and reflecting on concerns around artificial intelligence, which is a completely new area in this current moment, is how do we ensure that we safeguard data and people actually are able to have access to their rights and exercise these rights, and that we monitor the system to ensure that we do not end up having a case of technology exacerbating already existent digital inequalities and concerns. And that's my intervention and response. Thank you so much, Khaliwe.
Thanks so much for that, Chenai. Also, very interesting comments that are coming on the chat. So Avi from Cameroon is saying that as much as we have legislation and it's a first step, independent or neutral agency structure will provide trust and effective confidence and control. But this comment is also very interesting in what, just following up on what you just said, Chenai, in terms of issues to do with trust being important. But also there's a lot to think about in terms of also just digital literacy and people's awareness when they are on specific platforms. Because I remember you speaking to the fact that people are more in a rush to get a certain service or to be on a platform. And when you look at the marginal groups that you're talking about, you will find that for a lot of them, they don't have individual devices. The devices are shared. We're often very excited to be having a new app that's going to be monitoring my menstrual cycle, but I don't understand where the information is going to go to. So thank you very much for that, Chennai. It was very insightful. We're going to move over to Dumisani, who's going to give us a presentation that's going to specifically look at what are the data protection concerns for African business? And I think what's also interesting in relation to Chennai's presentation is the issue of, the siloed approach in terms of just implementation of policy. But I also want to acknowledge that as business, you play a huge role in the actual implementation of data protection policy by virtue of being data collectors yourselves, and also related to Chennai's conversation, unrolling of new digital initiatives. I know that Telco, you've just set up your digital natives initiative. So we would really like to hear what the data concerns for business are. So it's over to you now, Dumi.
Thank you so much, Koliwe. Thank you for having me on this platform representing business. That's quite a big job, but it's really fantastic to be taking part in a conversation that I think will be with us for the foreseeable future. I read an article the other day that talked about the fact that data protection, data privacy is going to be the next big thing from 2020 onwards. And I think the reasons are self-evident. Thank you to the ladies that have gone before, Chennai and Hlengiwe. You've done a fantastic job to set up the thinking. My name is Dumisani Ngala. I'm the Business Development Director in a company called Telco. We are a telecommunications company that operates largely within the Zimbabwean market, as well as the South African and Tswana market as well. What I've been asked to talk to this morning is the data protection concerns for African businesses. And I'll do that by way of just being guided through a presentation that maybe will just kind of guide our discussion this morning. So the framework within which I'm going to chat about the data protection concerns for business is as follows. I think it's important for us to, first of all, understand that African business is not one homogeneous whole. And that's why I say it's a very big thing to be talking to and talking on behalf of, because the business types in an African context are very, very different, and they have very, very different modalities and needs. And so I think when we are policy making and setting out these fantastic toolkits, one of the things that we're going to have to take into account is that the business landscape is not homogeneous. It is diverse. It has diverse players and diverse needs. And then the second thing that I'm going to talk to is what are the attitudes of these different business types and business players in regard to data, in regard to the data that they themselves hold and own, as well as in regard to the data that they collect from customers and other stakeholders. What are the attitudes that drive this? Because I think part of the big issue around policy making in the context of the business environment is a lot of it is understanding the attitudes, the attitudinal perspectives of a lot of these players and a lot of us as the business community. Then the third thing I'll tackle is this data that is being collected, excuse me, this data that's being collected, where is it being stored and who controls that data store? Because I think that can't be ignored when you're talking to data protection concerns, where the data is being collected to, where it's being stored, and who has control of that data store. And then the final thing then is to then address what concerns business might have around protection of data. I won't talk long, and maybe we can then engage in discussion thereafter. So first of all, talking to the first 2 points that I had on the previous slide around what are these different business types and what are their attitudes towards data? Clearly, in an African context, you'll find that, yes, we do have large enterprises, SMEs, and public enterprises, but undoubtedly, in the African context, we have a very large informal sector. And so that shapes a lot of how we should be thinking about data and the management thereof and the protection thereof. I read a statistic that says that in the African context, our informal sector ranges from anything from 20% in markets like Mauritius to up to 65 to 80% in other markets. And that's critical when we discuss this issue of data protection, because whether you're talking about formalized businesses or you're talking about the informal businesses themselves, formalized businesses, for example, big banks, are trying to that as a market because it is obviously the biggest buying market in some countries, such as my own. And at every point, you cannot help but interface with the informal sector. And now, as we know, the informal sector is very difficult to regulate. It's very difficult to, the touch points of regulation and policy making for this particular sector are quite challenging. And so if we are going to introduce policies, regulations that will be impactful in protecting data, we do have to take this into account, that the informal sector is a large part of what we're going to have to deal with when we do that. So when we look at the attitudes of whether it's the informal sector, the public enterprise, small enterprise, or large enterprises for that matter, towards data and data protection, I guess you'll find that large enterprises probably take it a little bit more seriously. Informal sector, probably it's not even a blip on the radar. But overall, my guess would be that the approach of most businesses to data right now, even though there's a tacit acknowledgement that data and data privacy and protection are important, despite the fact that there may be that tacit acknowledgement, I would say that the overall attitude towards data is casual. I'll give you a few examples to underscore this very thing. On Saturday, I attended a function at a well-known venue, which is quite established. And at the gate, the guard diligently asked us to provide our identity numbers, address, phone numbers, all but every kind of detail that you could provide was asked for. It was then manually recorded into a book. And I couldn't help but ask myself, what is the purpose of this information gathering? And I guess if that question had been posed to the guard, she herself wouldn't have known and wouldn't have been able to explain what protections or what cautions are being taken to protect this data that we're providing, which was all being written into a book. In fact, I could see on the one face of the book that was facing towards me, I could see a whole lot of information of the people that had gone prior into the venue. So that's how casual we are with our data. That's one example. Second example is in one of the markets in which we operate, there is a mobile money operator who inadvertently has exposed certain kinds of information to the public by typing a USSID related code into your phone. You can get the name of someone whose phone number you've had access to. I think that that's an inadvertent data breach, because it shouldn't be possible for any member of the public to use a phone number to reverse access someone's name and surname, real name and surname. That's a second example. That's how casual we are about our data. A third example, we as an operator in the market, one of the things that we are mandated to do by regulation is to capture a know your customer type of detail, KYC it's called, and make sure that it's stored in our databases with accurate ID information and accurate address information should the regulator require it. And one of the key struggles in getting accurate KYC information is the fact that often you will be supplied with incorrect or even false information from the public that are wanting to utilize the service. That indicates that there's a trust issue, and that also indicates that perhaps to some extent the public doesn't take seriously the issue of supplying their information accurately to their service providers. A final example of how casual we are in terms of data and its protection. I'm not sure when was the last time you were in most African public offices, like a police station or a passport office or an ID collection center. Often what you'll find is that files are stacked, whether it's on the floor or on filing cabinets, but not in secure filing cabinets either for that matter, but openly accessible to people that come in and come out of what is essentially a public office. So when I say that, I think our attitudinal positioning towards data, both as businesses and as the general public, is quite casual. I think all these examples do speak to the fact that educationally, attitudinally, we're not yet at a place where we understand, even though we give it positive assent, we don't yet quite understand the importance of data. Something else that we need to take into account when talking to data protection and privacy, or even before we start talking about data protection and privacy, is the issue of when businesses, whether it's in the informal sector or the more formal sector, are collecting data, whether it's from the public or storing their own data that's generated internally, where are they storing it? So the issue of data stores, I think, is big in Africa in particular. For informal markets, as we know, and in the African market in general, mobile is very, very pervasive. So a lot of what we will find is that a lot of the data capture points and a lot of the data storage points are somewhere between mobile phones and the cloud. And now the key question then becomes, who controls the data stores that capture this information, whether it's within a mobile ecosystem or it's on the cloud? Who is it that controls these data stores? So for informal markets, like I say, largely mobile phones. For small to medium enterprises, perhaps laptops, the email, or the cloud, or some other cloud-based storage system. Large enterprises perhaps are more organized in this regard, so they would take their information into an owned or a leased data center. And by the way, in terms of data centers in Africa, as far as I know, we still have only one tier 1 data center in the whole of Africa. So this is still an issue in the sense that if we only have one tier 1 data center in the whole of Africa, where is a lot of the data getting stored? So if some of the storage is going onto the cloud, is it staying within the jurisdiction within which it's supposed to be staying? And if not, if it's going out of jurisdiction, i.e. Another country or another legal jurisdiction, what regulations are there around this? And then finally, in terms of public enterprise, once again, some of it is being stored in the data center, some of it in the cloud, but I would still hazard that a lot in terms of public enterprise is still being stored in manual files, which aren't very well secured in their locations. So the issue of control of data stores, let me give one or two examples of why it's critical to be looking at that as we talk about data protection and privacy. I have come across a lot of public officials who will hand you a card which has their email address denoted as a Gmail address. Now, often what then occurs to my mind is, does this public official or even private business understand that the minute that you are corresponding on Gmail, this is a totally different jurisdiction, And if you're using that Gmail address for your business purposes or for public sector purposes or information, essentially, you're handing that information over to a totally different jurisdiction, potentially. And as has already been mentioned before, I think Koliwe mentioned it and Chinai mentioned it, that a lot of us utilize these services without reading the terms and conditions, without reading the legals behind what can and can't be done with my data, whether it's personal or it's business data. And I would hazard that a lot of small to medium enterprises are using cloud services that are not necessarily hosted in country. So as we talk about data protection and privacy, we need to be taking into account these data stores, where they're sitting, what are the legalities around where they're sitting, and whether we have complete control over the data that sits on those data stores. So one of the things that then occurs to me is that business securely sits as a gatekeeper to the data, to a lot of data that is collected within a jurisdiction or within the African context, and yet is very poorly equipped to conduct this gatekeeper role. Policymakers will make policy, government departments will demand for access to that data, but the real gatekeeper, which is business, at most times, whether it's informal or formal, is the real gatekeeper and may be quite poorly equipped in order to conduct this role. When I think about this gatekeeper role, I think, for example, about employees. How well do they know the data protection policies of the organization? And how ethical are they in terms of how they conduct that data? So it's one thing for an organization to subscribe to the toolkit and put in place that policy and then educate its employees about that policy. But then also the issue of attitude and ethics comes into play. I think it's not unusual in our markets to find competitors hiring employees off one another for the very purpose of accessing data that is within one organization, merely by employing someone who's privy or who has been privy to that data. When it comes to customers, like I illustrated in one of my examples, one of the key things with customers is customers have trust issues with the organizations to whom they're handing their data, and therefore are more likely to falsify the information that has been handed over or to obscure the information in ways that make it non-compliant with regulation. Then obviously there's massive security concerns, and I think just in the last 24 months, we've seen in our market, we've seen a lot of government and public websites, as well as I'm sure many private websites, being hacked by hackers, both internal and external, who hack for various reasons. Some may just be for fun, and some may be for more nefarious purposes of stealing information. And this is a massive, massive concern. Yet attitudinally, once again, most entities seem to be quite casual about how they conduct their security for their organization or for their customers' information. And then finally, another way that business is a gatekeeper and has to interface with international markets. Our markets, the markets within which we operate, and a lot of the customers which we service are customers that interface with the international market, for example, the EU, quite a lot. And that then adds an extra layer of burden to be a proper gatekeeper to information, because not only is there a requirement for compliance locally, but there's also a requirement for compliance to international data privacy laws, such as the GDPR that has been promulgated in the EU. And a lot of businesses may or may not know how to navigate those kind of situations, and therefore it curtails the economic activity that they could conduct with international organizations if they don't know the know-how of how to do that. So just in wrapping up and summarizing what I believe to be the 5 key areas that, or concerns, as it were, for business in terms of data protection and privacy is, number one, the issue of trust. The public has very low trust levels with public entities and private entities and how they're going to manage the information. And so that leads to potential falsification of information. And even the verification of the information that is available to an entity and that is supposed to be passed on to regulators is therefore suspect, because there is this big trust issue. And so one of the things that I think, as we are policy making and creating this environment, is to understand that we're dealing in an environment of high mistrust because of many issues. But that does impact the data that is going to be collected, the data that is going to be held, and the data that's going to be distributed to public entities. Secondly, and I think this one can't be ignored at all, the cost of compliance. For a medium to large entity, the costs of compliance are pretty high, let alone if we're talking about an up to 80% informal sector. The costs of compliance, the costs of being compliant with such regulations is something we can't ignore. And unfortunately, in our markets, we tend to have very weak institutions that are not as helpful to entrepreneurial businesses or to informal sector businesses as they could be, in order to assist to ensure that compliance doesn't become a hurdle. So the cost of compliance cannot be underestimated. Then the third issue is our attitude tends to be quite casual about data, its importance, the privacy thereof. And so we need, at a wholesale macro level, we need education, right down to the business level. We need education around how to do that and who needs to be doing that. The fourth thing is control. We need to be strongly controlling the data that we're then expected to protect. And that can't be controlled if it's sitting in data stores that are outside of our control. The final thing is, how do we access the data that's critical to make sure to verify the data that we hold? I think I'm out of time, but those would be the 5 things that I think are the concerns for business. Thanks, Kholiwe.
Thank you so much, Dumisani. I think this has been great in that I like the fact that you began by breaking down business, because often in our conversations, we are looking at business as a homogeneous group. But I think what this has done has also made us realize that we need to critically point out even the recommendations that we've been making to business from a contextual and real level. I see there's quite a number of issues and questions that were directed to you as you spoke. I would like to ask you to just go through them so that after Advocate Tlakula speaks, we can then just open up for a plenary discussion. So I'm going to hand over to Advocate Phansi Tlakula, who's the chairperson of the South African Information Regulator, to take up the mic. Over to you, Phansi.
Good morning to everyone. Let me thank the organizers for inviting us to participate in this webinar. I also want to begin by just paying tribute and remembering the victims of gender-based violence at this point in time, now that we are beginning the 16 days of no violence against women. I'm obviously speaking from the point of view of a regulator, and just to give you general information on what I think an effective regulator should be and what should it do. The first thing that I want to say is, for those who are not from this country, to just give a brief background of the information regulator, which is a statutory body consisting of 5 members. It is independent and it is accountable to the National Assembly. The regulator consists of the chairperson, which is myself, and 5 members. The 5 members, 3 of them, including myself, are full-time and 2 are part-time members. I think just referencing what Hlengiwe indicated in her presentation, I think issues of the independence of the regulatory authority is important because it engenders trust, and because issues of trust have also been raised. So this independence, I think it's both at a normative level and at a functional level. I think at a normative level, we're talking about the method of appointment of members of the authority. It's important that the appointment procedure should be open and it should be transparent for there to be trust in the authority. In our situation in South Africa, the appointment process is handled or initiated by the Portfolio Committee on Justice and Correctional Services, which is a committee of the National Assembly. They put up a notice in the newspaper calling people to be nominated. You can't nominate yourself, you have to be nominated. They then put the CVs of the people who have been nominated in the media and on the website of Parliament and ask for comments from the public so that members of the public are given the opportunity to comment on the fitness of the person who has been nominated. Thereafter, the Portfolio Committee then comes up with a short list of nominated candidates, and the shortlisted candidates will then be interviewed by members of the committee, and the interviews are open to the public and to the media. And then thereafter, the committee will then propose 5 names out of the 5 successful candidates who from those who were nominated, those who were interviewed actually. And the 5 names will then be submitted to the National Assembly, and the National Assembly will then have to vote by a vote of simple majority for the 5 names and propose who should be the chairperson in among those. And the names are then given to the president of the country, who then makes the formal appointment. And if the president is not satisfied with one of the members, he or she cannot just change. He has to take the process back to Parliament. The appointment is for a period of 5 years, which is renewable. The renewal is not automatic. You have to go through the whole process once again if you want to serve for the second term. The unfortunate part in the legislation is that they forgot to put term limits, which I think it's a mistake, or they did that inadvertently, because I think it's always important to have term limits for members of authorities such as ours, so that they can serve for 1 term renewable ones, so that you don't have people being members of these bodies for life. The second thing in my experience, I think, which is important, and I think that is not the norm globally and on the African continent. Our regulator is responsible for the promotion, protection, and enforcement of 2 rights: the right to privacy as it relates to the protection of personal information, and it is also responsible for the right of access to information. I think it is important for an authority such as ours, or the one that deals with data protection, to deal with or to be responsible for access to information, because the 2 rights go together and one balances the other. Because if you have privacy without access to information, then you can inadvertently introduce opaqueness. So it is important for these rights to go together and to be regulated by the same authority. And it is unfortunate that globally there are very few organizations that have a dual mandate. As far as I know, on the continent is ourselves. I know that the UK, their authority also has a dual mandate, and Mexico. On the African continent, we have been pushing through we have the network for African data protection authorities. We also have the African network of information commissioners. We've been pushing for, this dual mandate thing, but it has not quite worked. I realize that most countries have two separate organizations responsible for access to information and privacy. It is also important to say that to ensure the independence of these organizations, they should not report or should not be part of the executive. They should report to the National Assembly. On our continent, I realize that most data protection authorities are part of ministries of information, which I find to be quite problematic, to put it bluntly, because data protection authorities are super regulators in our view. They regulate everybody. Ministries of information and communication are responsible for coming up with policies on things such as big data, on fourth industrial revolution and so forth, which are data protection or which are data-based. So for me, it is problematic for a data protection authority to be located within a ministry of communication or information and communication, when in actual fact, it has to regulate that ministry and also to ensure that the policies that are adopted by such a ministry are compliant with data protection laws and regulations. What I will do, Koliwe, as I go, I will then touch on some of the issues that have been raised by the panelists that went before me. It is important for a data protection authority to have a broad mandate, and mandate to educate, to monitor and enforce compliance. It has to have a mandate to consult with interested parties, to handle complaints, to issue codes of conduct, and to facilitate cross-border cooperation in the enforcement of privacy laws. We are fortunate because our law is quite broad and it gives us quite a broad mandate. Over and above that, I think what is important is for the authority to have effective enforcement powers, because without that, then it will not be able to execute its mandate effectively and efficiently. And the mandate has to be so broad that there has to be an open-ended section in the mandate that says the authority can do anything incidental to the execution of the mandate contained in the legislation. And that then gives the authority the power to issue guidance notes, for instance, because in some instances, you find that the authority has an express mandate to issue guidelines. But if you don't have that open-ended, all-encompassing section in the legislation, the authority might not be able to do other incidental things. For instance, to issue guidance notes. In our country, when COVID-19 broke and when the national state of disaster was declared, we were able to issue a guidance note on the protection of personal information in the management of COVID-19. And we used that all-encompassing provision in our mandate to issue that. And in the past, we have also issued a guidance note on the processing of personal information of voters by political parties for campaigning purposes. And as I do this, I am responding to the issue that has been raised, or that was raised by Hlengiwe, on how data protection intersects with the right to vote, among others. And at the beginning of this year, we held a colloquium with the Independent Electoral Commission to just look at how their legislation complies with data protection principles, more so that our legislation, which is the Protection of Personal Information Act, has it has primacy, which means that it takes precedence over any other act, especially when it comes to protection of personal information. And I must say and commend the Electoral Commission, because we went through their legislation and we were able to indicate to them the problematic aspects in their legislation. To give an example, they had a section in their legislation that says that upon payment of a fee, they can make the voters' roll available to any person. And we all know that the voters' list contains a lot of not only personal information, but also special personal information, or sensitive personal information, as it is called in other countries. It contains our names, it contains addresses, it contains also the ID numbers of voters, and ID is a unique identifier. In some countries, you'll find that the voters list also contains biometric data. So we impressed upon them that the voters roll can only be used for election purposes and for no other purposes. So you cannot make it available to any person on payment of a fee. And I realized that indeed when they submitted their proposed amendments to Parliament, they actually proposed that particular provision in their act should be repealed. Talking about enforcement, effective enforcement powers, for a data protection authority to be able to function effectively in enforcing compliance, it should be able to compel persons to appear before it, must have powers to search premises, to seize documents, and it must make binding decisions after investigation of a complaint, and its decisions should only be reversed by a court of law. And in our case, we are fortunate because we also, the law provides for the establishment of an enforcement committee, which we can refer a complaint to after an investigation. And anyone who is not satisfied with a decision that we have taken after an investigation can only challenge that decision on appeal in a court of law. And I think the authority, for it to be effective, must be able to issue sanctions and also have sanctions and fines. For instance, in our case, we can administer or issue an administrative fine of up to 10 million rands, and imprisonment of up to 10 years for non-compliance with an enforcement notice. For a data protection authority to be able to function effectively, it must be properly funded. And this is one of the biggest challenges, and COVID has not made it easy. And for us, unfortunately, we're setting up, during the process of setting up, then COVID came. And we know that money is very difficult to come by. So I think most data protection authorities and most human rights organizations are going to suffer, because government will have to, or is already prioritizing other areas such as health and education, and human rights organizations are going to suffer. One of the challenges really is the skills requirement. As we are ourselves are in the process of establishing our organization and employing people, we find that there are very few people who have skills in this area, and understandably so, because it is a new area of of law, of IT, and so on. That is why I always impress on young people, particularly young lawyers, to ensure that they equip themselves in this new emerging area of law so that they are able to either defend people, defend companies and public bodies, or even we can use them in our work. Just to answer some of the issues raised by Chena, there is a perception that data protection is for the affluent people. But those of us who are South Africans will remember the case of the Black Sash versus Minister of Social Development, where a company that was responsible for paying social grants to poor people actually abused the data of poor people without their informed consent. They gave this data to all sorts of service providers who then use that data to market goods and services to the poor people without informed consent. And this then led to the situation where, an old person without knowing consents to a funeral policy being taking a funeral policy, and the premiums being deducted from the little social grant that she or he received. And this matter, when it went to court, the court then held that, and it was the Constitutional Court, that the personal information of grant beneficiaries should be used only for payment of grants and for no other purposes, because that personal information was collected for that particular purpose, which is payment of grants, and that it cannot be used for any other purpose. And this case, for me, indicates the importance of public awareness on the importance of data. And unfortunately, there are very few civil society organizations that operate in this area that conduct public awareness, particularly in plain language in the communities. We did one public awareness campaign with the Black Sash, the organization that had brought the case that I've just mentioned to the Constitutional Court. And we did that in the Eastern Cape, and it was quite an eye-opener to do that kind of plain language, public awareness education session with ordinary people in the village. I saw a question here that data protection and privacy stifles innovation. My response to that is simply that data protection laws do not prevent people from going on with their businesses. It simply says that if you collect personal information, ensure that you comply with the 8 conditions or principles for processing of personal information. And we need that paradigm shift. I think data protection has been punted as an IT issue. And I always insist that data protection is a human rights issue. It's associated with the right to privacy and the right to human dignity. And if you take that route, then you will appreciate the importance of data and how it is closely linked to human dignity. Therefore, my response is, if you cannot protect our data, please don't collect it. And it's simple as that. If you collect it, make sure that you comply with the principles for the processing of that, for the processing of personal information, so that you can protect my privacy and protect my human dignity. And there are issues that were also raised by Dumisani as I complete. I think the overall attitude towards data is casual. And in South Africa, I think it's more casual than anywhere else. I will shock you to tell you that between January and now in this country, we now have 35 data breaches. we are coming to a situation where every 2 weeks there's a data breach in this country. I say so, I know, because it is an obligation under our law for a responsible party that has been breached to notify us. So that is why I know, but it is quite scary. We are sitting dark for data breaches in this country. And the reason for that is that people know that the data protection law, even if it has come into operation, enforcement will only come into operation as of the 1st of July, because all responsible parties in terms of the law have a grace period to comply, and that grace period ends on the 30th of June 2021, and it is only after it is only on the 1st of July 2021 that the information regulator will be able to enforce its powers. The cost of compliance, Dumisani, it's quite high indeed, but I think if you look at the cost of compliance vis-a-vis the reputational risk for non-compliance, I think it is important for public and private bodies to ensure compliance. The casualness that Dumisani spoke about doesn't just occur in security, in the security sphere. You know, when you enter a complex, as she indicated, you are asked all sorts and manner of information, but also in the conferences that we attend. You attend a conference, there is a photographer who takes your photo without your consent. I think we need a paradigm shift so that, you know, people know that when they attend the conference, there has to be permission that they will be recorded. They must give consent to be recorded. They must give consent that their photo should be taken and that their photo can be shared. And this has to be some of the standard things that we need to do. And that's the paradigm shift that is required. And we need data protection activists. I don't think we have enough data protection activists, particularly in civil society organizations. I know that because I have worked a lot with access to information activists or the right to know activists. But I think we also need to ensure that we build capacity in data protection and have more civil society organization operating in this area. As I conclude, in the work that we do, there are 3 sectors that are problematic insofar as data protection is concerned. The direct marketing sector is quite problematic. We know that we receive all these unsolicited direct marketing messages at all times. The financial sector is quite problematic. The mobile service providers, quite problematic. The gated communities are quite problematic because, as Dumisani has said, when we enter these communities, all sorts and manner of personal information is collected, and we know that the security of this personal information is not at all times secured. Okay, let me stop here because I'm mindful of the time. We only have 5 minutes, and I'll stop here and I'll take questions. Thank you very much.
Thank you so much, Pansy, for that. Yes, I think most of the comments that came to you directly, and I'll ask you to just respond to them in a minute, is a question that came from Lydian. She was asking what the relationship should be between an effective or a trusted or independent regulator and the ministry that's in charge of ICTs. And I think this is an important question because it relates to who exactly does the regulator report to. Then for Dumisani, soon after Pansy, if you could respond to the issue of businesses in relation to when you assess, based on your presentation, how you think that they will fare with this African Free Trade Agreement. Do you think that this is actually going to be realistic? Thank you, Melody, for responding to the question and clarifying the case. So I'm going to hand over quickly. Chennai, I don't see any questions for you. The rest are just comments. So quickly, Phansi, then Dumisani. Then I will ask at the end of Dumisani's presentation that we all turn on our cameras if we are in agreement to get a group picture. So over to you, Phansi.
Were there questions meant for me? I was looking at the chat. I mean, I got distracted.
No, the only one you didn't answer is the one on the relationship between a Ministry of ICTs and the regulator.
Oh, yeah. Of course, the regulator has to have a relationship with all ministries. The Ministry of ICT, actually, we've just had a meeting not so long ago with the Minister of Digital Technology in our country to say, look, they have to adopt policies. That's why they are there. Policies on data, on big data, and so on. Our function, and it is a mandate in the law, is to ensure that any policy that has an impact on data protection, we have to look at that policy and satisfy ourselves that it complies with data protection principles. So that's the relationship. And that relationship is beginning to unfold in our case, because at all times, what now is happening is when any ministry, or even in the private sector, if they have to adopt a policy or implement a policy, they come to us and say, can you look at our policy? Is it compliant with legislation? And that's the dynamic relationship that we must have. And that is why we are saying we are a super regulator, because even Parliament, we report to the National Assembly, but we regulate Parliament in the manner in which they process personal information of data subjects, be they members of Parliament, be they staff of Parliament. So that is why a data protection authority can never be located within a ministry, because that creates conflict or a potential conflict of interest, particularly in situations where there will be a complaint, for instance, against the ministry. Thank you very much.
Thanks, Phansi. Over to you, Dumi, quickly.
Thank you so much. So the question, I think, had to do with how businesses are tipped to fare against the African Continental Free Trade Area that's been put in place. And I think the short answer to that is that while it's very exciting to have a free trade area and it expands the market access for a lot of businesses, I think the challenge is going to be specifically around information access. If you layer it down, the Africa itself is then broken up into the regional economic communities, which are then broken up into the countries and the industries and then the businesses themselves. The challenge is, even at a business level, most information is not being treated correctly or stored correctly. Then at an industry level, there's information sharing is very, very difficult. So one finds it difficult to see how, if we're finding it difficult even at a business and industry level, to have information and data that's stored centrally, that's reliable, and that can be shared accurately, how we're going to do it at a continental level. So we've got a lot of work to be done. It's not impossible, but I think it's going to require a lot of concerted effort from all the stakeholders.
Thank you so much for that, Dumi. I would like to take the opportunity to thank all the panelists. This was a really exciting conversation. We had lots of new issues to learn from. Also, some critical recommendations coming from the speakers in terms of just what are the priorities for members of especially civil society, business, and also for those researchers who are already looking at the different or varying dimensions of data protection. So on that note, I would like to request that those of you who would like to be part of the gallery shot, you can quickly turn on your camera. For those of you who don't, you can feel free to just exit the meeting. Thank you so much. And over to you, Peter.
Okay, yeah, thank you so much.